The U.S. Supreme Court rules New York concealed firearms restriction violates Second Amendment. That is the big topic that we'll jump right into. So, Alexander, Robert, the floor is yours.
Absolutely. Can I just say, this is a point I want to emphasize to our American viewers. The Supreme Court of the United States is the single most important court in the world. Its decisions are followed everywhere by lawyers, everybody who is a jurist of any standing, not just in Britain, not just in common law jurisdictions, even in civil jurisdictions, that's to say European type jurisdictions. Everybody follows what the Supreme Court does. And there's two reasons for this. One is obviously because the United States is the United States, and the High Court of the United States is a court which we're going to always be interested in because of the power of the United States. But secondly, because it is the first constitutional court ever created. No other country ever created a constitutional court before. No other country has ever had a constitution like that of the United States. And that means that constitutional lawyers everywhere look to the Supreme Court of the United States to determine constitutional issues. And that has enormous influence. Now, I can give examples of this. I mean, we hear an awful lot, for example, about the European Convention on Human Rights. It's often said that this was British inspired. It's British inspired, looking at the development of human rights law as the English understood it or misunderstood it in the United States, without actually importing directly American ideas. American ideas are all over it. So everybody in the legal community is incredibly excited about these decisions that are coming out of the United States Supreme Court. We are very frustrated that we were promised some today, which don't seem to have come. But I think we've had a big one, a very important one. And Robert Barnes is the man to tell us all about it and what it means.
Yes, so this was the last scheduled calendar day for the Supreme Court to issue any opinions for this term. Each term is kind of usually starts in October of the prior calendar year. So October 2021 through May 2022, with the term usually wrapping up by writing and issuing a bunch of published opinions by the end of June. Now, the Supreme Court had issued that the only day it had left on its calendar before its summer break was today. So the assumption, usually that means they will issue all their opinions on that. Sometimes those opinions will get delayed for, sometimes they will issue decisions as late as the first week of July. But that's usually the latest they go. They had several big cases that had not issued opinions yet that people were really sitting on. Earlier this week, they only issued a school decision about the right of freedom of religious expression. Means that the state is supposed to be neutral on religion both ways, neutral and not favoring a specific religion, but also neutral and not discriminating against a religious expression. And so that decision was a good decision on the main school system. But the big ones today, no abortion decision actually published, no big EPA decision actually published. No big decision on school prayer issues about prayer after school in this particular context. But they did issue one of the other big ones, which was the Second Amendment case. And this is New York's concealed and carry law and the way in which it restricts and regulates gun rights in New York. And the law had a twofold significance. One was the specific issue of concealed and carry rights across the country and whether various state laws attempting to prohibit that were constitutional. And this goes back to whether the Second Amendment is limited to the home. For those that are out there, the Second Amendment that may not be very familiar with U.S. law, the Bill of Rights, the first 10 amendments added to the U.S. Constitution, which was a precondition for a bunch of people approving the Constitution's change from the original Articles of Confederation, included a Second Amendment, which was the right to keep and bear arms. It was, as Justice Scalia said, and I think this correctly reflects its history, a right of self-defense, or another way to think of it is empowering the individual against the state and against others. In other words, does the state have a complete monopoly on both the legal right of violence as well as the certain means of violence, certain tools of violence? As a practical matter, the state has the latter these days in terms of nuclear weapons and things like that. But the goal was that the state would not have a legal monopoly on the right of violence, nor on the means of violence, and that the ordinary individual's right in America would be protected by their individual right to keep and bear arms. The lower courts had been trying to limit this. The U.S. Supreme Court famously in Heller said, yes, there's a Second Amendment right to keep and bear arms. That's an individual right. There was language in the Second Amendment that talked about protecting a militia. Now, the idea was there wouldn't be a national standing army. Kind of ironic and bridges into our current issues and conversation, but there wouldn't be. Don't worry, anybody. We're not going to have a direct national tax system, and don't worry, we're never going to have a direct national standing army. Neither one of those promises turned out all that great. But one of the ways in which instead if you wanted to have an army, you had to call upon the militia. As a practical matter, what it did is it provided a political check on the abuse of power. Because there was no professional standing army, you would have to resort to the appeal to the ordinary person at the local level. And it sort of democratized military foreign policy potentially and domestic, quote unquote, insurrection policy, because if they wouldn't participate, you had nobody to go to. I mean, anybody who studied the whole history of governments and societies around the world know how important it is in terms of power, whether there's a national standing army or not. That was part of the reason for the militia. But it was all about a general political, philosophical purpose of empowering the individual against the state. Or as a reflection and expression of the state, the individual held the power to keep and bear arms, not the centralized power of the state and a professional army. The professional army part, that ship has sailed for some time. The courts kind of ignored that. But they finally restored the Second Amendment right in the Heller case. But then the question is it limited to the home? Or do you have a right of self-defense wherever you go? Do you have a right to keep and bear arms, regardless of whether you're in your home, in your business, in your car, on the street, traveling between states, et cetera? And that's what the concealed and carry issue was more broadly about. And what the U.S. Supreme Court decided today, a decision issued 6-3, written by the one and only Justice Thomas, who has once again saved Republicans from their own self-inflicted political wounds, because just this week they also are about to pass a major gun control law that has a lot of the Republican base, the populist Trumpist wing of the base, very unhappy. Now Justice Thomas's opinion is going to make them twice as happy, so that will limit the political damage of the mistake of Senate Republicans going along with a gun control proposal after the mass shooting incident in Texas at a school called Uvalde. The Supreme Court actually referenced the issues concerning the Buffalo mass shooting actually that occurred. So the net effect of the decision is that they have expanded. They've said the New York law is unconstitutional, that they've expanded the Second Amendment right to be outside the context of the home, that it applies in the concealed and carry and other contexts. Not only that, they wrote the opinion in such a way that the big issue was how to analyze gun laws, gun control laws, gun limiting, gun restricting laws. And right now, in the past, prior to this decision, it was kind of confused, and often they provided a lot of discretion to the states, particularly here in the Ninth Circuit out west. They had really allowed the states to do a lot of limitations on guns using a deferential standard of review. They have also modified that, so the standard of review is no longer near as deferential. So it is the most, other than Heller itself, the biggest Second Amendment decision issued today is the biggest Second Amendment decision issued by the U.S. Supreme Court in history, in American history. And as you note, these kind of cases, the right of self-defense, while some of these issues are specific and unique to the United States textual language in the Second Amendment, it reflects a broader principle, a broader premise that will be applicable in analogous context around the globe about what the right of self-defense is more broadly, and empowering the individual as opposed to the state, which is the philosophical principle this is. And it's a massive win for those of us that have a robust view of the Second Amendment.
Can I just make a few historical observations about this? Because one of the things I have always tried to get people in Britain to understand, and I also should say people in the United States, is that the United States is the creation of a revolution. And the Constitution of the United States, in the context of the world that the United States rebelled against, is a profoundly revolutionary document. In 18th century England, the right to bear arms was limited. For example, if you carried a sword, you had to be a gentleman. In other words, you had to be a member of the aristocracy and of the class just below the aristocracy, which was the gentry, the people who owned the land, who in effect controlled English society at that time. If you did not belong to those classes, carrying a sword was actually something that could get you into very serious trouble. It was something that, you know, the society at that time in England was deeply skeptical about. Not just skeptical about, I mean, it was dangerous to do. It was not exactly illegal, but effectively illegal. And not just this, but of course, if we're talking about standing armies, kings in Europe had standing armies. And of course, England again is a monarchy. The standing army is operated by the aristocracy. The aristocracy are in charge of the courts. We have justices of the peace, who are, of course, at that time drawn from the landed families, the same people who were entitled to bear arms. And they control the judiciary, they control the military, and as a result, that effectively meant you had a certain control of society. So coming along and saying everybody has a right to bear arms, and everybody has a right to constitute themselves in a militia is a revolutionary act. It means that the power of elites is challenged. It's challenged head on. And of course, if you're talking about the right to self-defense, well, again, if only some people are entitled to bear arms and not others, which is the situation in 18th century England, that's a pretty radical thing to entrench in your constitution as well. So we're talking about a revolutionary document, and we have, I suspect, in the United States, people who are not happy with that and who've been trying to chip away at it steadily and systematically over the decades, the centuries since it was created. And I think this has accelerated a lot in recent years. And that probably reflects, if I can say, the Anglicization of a part of the American elite, which we've discussed in many places, in many programs before. So I just wanted to give that context, because I think people don't fully understand the revolutionary implications of this going backwards, and also quite why there is this attachment in the United States, which to the right to bear arms. I think it is one that perhaps people in the United States, it's passed down, it's passed through. It may not be always understood or explained in the way that I have just done, but people in the United States are profoundly attached to it because of that history, which explains its democratic importance. It is something that people in the United States see as both empowering and also at the same time as a defense against overweening governmental power. Now, tell us a little bit about what the opposition is all about. Why are the people who want to restrict this right in the United States? Why are they trying to reinterpret the Constitution in this way? Why are they trying to chip away at the Second Amendment? And who is it that's coming from it? I mean, I get the impression that President Biden is keen to reduce this right as far as possible. Obama, the same. I mean, what is the rationale for chipping it away? And what are the legal arguments that are adopted in trying to do it?
So it's sort of a bifurcated aspect. What they share in common, the people who oppose an expansive, robust Second Amendment, is that they're fundamentally statist. And so there are people who believe the state should have a monopoly on certain kinds of power, that the individual should not have the right even of self-defense in certain contexts. This was the debate in the Rittenhouse case in part in terms of the court of public opinion. These are, they tend to be politically selective when they say they want the right of self-defense, but there are people who fundamentally think the state should have a monopoly on the right to use violence and don't want the individual to be able to have that. And the other attribute of it is the people who truly believe that the right of self-defense and the popularity of guns is the reason for certain gun violence in the United States. And in recent time, that has been focused on mass shooting events, whether it's particularly school shootings since Columbine, but other events that have taken place. And those that have studied it in detail, including people at liberal organizations like 538, a guy that was at PBS, another guy who was at NPR, who've all written that when you study it in great detail, restrictions on guns, access to guns, use of guns, does not correspond or correlate to reduced gun violence. That gun violence is almost everyone who commits illegal gun violence does so illegally in the sense that they not only obviously they're committing a crime in the process, but usually their gun is purchased illegally. So that it's not that creating a big black market for guns, which is what a lot of their practical effects of their proposals would be, would not in fact bring about a reduced, just ask Mexico. Mexico has lots of gun control laws, hasn't stopped the cartels much. So there's really no, in fact, globally, there's not much correlation between limits on gun rights and limits on gun violence. And so you have different cultures that have used guns more or less. I mean, for example, in the UK, much lower history of using guns and violence. Now, that doesn't stop like knives and a lot of other things from being used. But usually that is a stronger predictor or correlator to gun violence than is lawful right of access to guns. So it's a mixture of two groups, people who I think have a mistaken belief that it's like anything that people want to ban. It's like, whether it's drugs or alcohol, historically, if something is pretty easy to make, pretty easy to transport, pretty easy to sell, people will get their hands on it if they want it. The reason why a lot of people have illegally owned guns that are engaged in crime is they don't attract and trace back to them. So I mean, this is kind of common sense. And it just creates a black market that enhances additional problems. Any attempt to regulate something that's popular and desired and easily accessible has really never been successful. Our regulatory efforts on alcohol in the 1920s helped birth the American mob's power in the United States. Our attempts to control drugs has only birthed all kinds of drug dealer wealth and drug cartels around the world. It hasn't worked. We haven't restricted at all the actual use of drugs, and even the illegal drugs. And then on top of that, gun control hasn't shown much. I mean, Chicago has some of the strictest gun laws in the world. They also have some of the highest gun violence in the world. I mean, it just doesn't really correlate. So that's where part of it is. Part of it is people who want to say the Second Amendment is only for a militia, and the militia should be controlled by either Congress or the governor, and therefore your gun rights are really contingent on whether Congress or the governor thinks you should have them. That kind of a Second Amendment interpretation. They would take the militia clause as a limiting clause on the plain language that says the right to keep and bear arms. It doesn't really mean right to keep and bear arms, according to this liberal legal analysis. But I think so. That's the legal argument is a limitation on the Second Amendment as not being an individual right to keep and bear arms. And the political argument is guns are bad, leads to gun violence. Mm-hmm. And hey, we don't want the ordinary person to have guns, do we? And, Bowling for Columbine, Michael Moore's movie where he talks to people. That was his whole pitch. And part of the pitch also was what arms fit within that. I mean, historically, in the United States, a cannon actually fit within the Second Amendment. Sometimes people say, oh, it's not like you could have a cannon or a bazooka or whatever. It's like, actually, yes. Back then you could. It was part of the ability of a ship to defend itself was considered included within the Second Amendment. Mm-hmm. But obviously, it's not practical for it to apply to, like, nuclear weapons, right? So that's where the question becomes we live in a different era in terms of armaments and munitions and military violent capability. We have weapons unimaginable at the time of the Second Amendment. The philosophical principle would be that would continue to protect the individual. What weapon is necessary to protect them? Certain mass offensive weapons would not be needed to protect them. But that's where some debate takes place. But practically speaking, the Supreme Court has never extended it that far to just any kind of weapon system. It's still something practical and useful in day-to-day life, usually a gun.
But you have extensive jurisprudence about this. You have precedents which have interpreted, presumably, the Second Amendment going back into the 19th century. And of course, the point to understand about this is that judicial interpretation, particularly at the level of the Supreme Court, is or is intended to be authoritative and sometimes binding. So if the Second Amendment is interpreted consistently to mean a certain thing, that there is a right to bear arms, then it's rather, I think, shall we say, wrong for people who are not part of that process of judicial interpretation to try to limit and reconstruct that interpretation, in that the meaning of that provision in a more narrow way than the Supreme Court has historically done. Is that correct? I mean, do you have that history of precedents that sort of build and explain the Second Amendment going way back into its origins?
From a historical perspective, yes. From a Supreme Court perspective, not so much. Right. Because the U.S. Supreme Court never, now you could argue, didn't really have cause to do so. There was cause to do so, in my view, historically, but they played games about what they did. So I was recently on vacation in New Orleans and went on a tour with a guy I would say comes from a sort of black nationalist, black populist combined tradition in Louisiana, which is kind of unique to Louisiana, but also very robust. You know, Huey P. Newton, founder of the Black Panthers in America, he is named after Huey P. Long, the great populist governor of Louisiana, because his mama was a big fan. So you have some unusual, like everything in New Orleans and Louisiana, you got some unusual overlaps. But he was talking about, he kept coming back over and over again to one of the key restrictions on freed blacks in New Orleans and Louisiana was the inability to keep and bear arms. There were the restriction on gun rights as critical and essential to the ability of the French to oppress their individual liberty aspirations and ambitions. And so so in that sense, politically, historically, there's a robust historical understanding of what this meant to the ordinary person and how it could be misused and abused if not enforced. But the U.S. Supreme Court kind of dodged the issue. Heller was really the first major Second Amendment decision of its kind. And that was just about a decade or so ago. So so in that sense, we don't have a robust Supreme Court interpretation of a lot of precedents on the Second Amendment. We do have a pretty broad, clear public understanding of what it meant philosophically to the founders. And I include often there's a mistaken elite-based focus on what the Constitution means when people say founders. They often mean somebody who was sitting in the hall, somebody who was sitting in the halls of Congress. My view of founders is, I mean, the founding generation, the people who fought in the wars, the people who voted on the Constitution, the people who voted, the people who were publicly participating. Now, that had certain legal exclusions at the time, but it was still one of the broadest public participations. And that's all the Barneses in Rhode Island originally voted against the Constitution because it did not have a Bill of Rights to it. Like, no thanks. In Rhode Island, we tried to hold out on currency, right? The right to print our own currency and some other stuff. And then they sent in that army that they said they weren't going to have. And, he said, okay, never mind. We'll come back to that later. But so that, for the founding generation, this is what the Second Amendment meant. The two great worries was a national standing army, and a way of reflecting that was we do not have a legal monopoly on the power and tools of violence in the centralized state. It is I, as an individual's natural right to do so, and it is a critical, essential, fundamental restriction on the misconduct of the state, as we've witnessed ever since we've had a professional standing army, quite frankly, in terms of our foreign policy especially. So, but yeah, the Supreme Court precedents are thin on this, and that's why it was an area they really needed to go to the historical original understanding and enforce it in plain language. They got part of the way with Heller. They got the rest of the way today.
And tell us about the Supreme Court decision now. Who was in favor and who was against? I say that because it was a 6-3 decision. Who were the three who were against? Obviously, the three liberals,
Yes.
But what was their argument? What was their point? I mean, what argument were they making?
The three liberals have long held that the Second Amendment does not give an individual person the right to keep and bear arms. So they still hold that position, that the Second Amendment is just a militia empowerment provision, and which, by the way, makes no sense why you'd have you don't need an amendment to the Constitution to deal with how you're going to arm a militia. I mean, it's historically kind of a ludicrous argument. But it's because they have a first phrase that's connected to the second phrase, but the first phrase is not limiting on the second, or otherwise there's a waste of space in the second in the Bill of Rights. But they still hold to that position, and so and now they also wanted to keep what other limits were there. Limits in terms of at least limit it to the home, at least limit it to, and the home being an issue because this goes into the Fourth Amendment as well. There's been this historical tendency to really say, in your own home, we don't want there to be an invasion of privacy. In your own home, we don't want that. We want you to be able to have a right of self-defense. It's developed almost a mythical status in American law, and it's one that's beyond what, especially in the modern age. I mean, the idea that the right of self-defense is only in your home makes no sense. The idea that there's a right of privacy only in your own home, it may be heightened in that context in terms of reasonableness of expectations for a search or seizure analysis under the Fourth Amendment, but it's not the sole and whole place that you have privacy interest or self-defense interest. But they wanted to keep it limited to that as well. They also didn't want the shift of standards so that there's no longer, because despite the Supreme Court saying you have a right to keep and bear arms, a lot of lower courts, especially the Ninth Circuit, keeps affirming a whole bunch of gun law restrictions. But California is always coming up with new restrictions. Restrictions that, again, only disparately impact law-abiding people, because it hasn't stopped gun violence at all in California. They keep increasing the legal restrictions. Gun violence keeps rising. So, there's just, but that, because to me, it's about the state having as much power as possible and the individual having as little as possible. But that's their argument. Their argument falls within those three categories that, hey, at least it lets it keep this bifurcated legal standard that allowed a lot of gun restrictions to stay in place. Let's not extend it meaningfully beyond the home in terms of gun rights. And really, this is supposed to be a militia clause, not an individual clause anyway. Now, somebody in the chat mentioned how this impacts the 10th Amendment. Here, the 14th Amendment changed the game. So the 14th Amendment and the net effect of the Civil War is such that, and as to that super chat question, there's already states passing laws making changes, and the Congress is right now. All of it's going to be challenged again, and there's current cases pending in a bunch of federal courts where courts have already issued opinion that they're now probably going to have to go back and reconsider in light of this decision, because this goes beyond concealed and carry in New York. Because what they did is they changed the legal analysis. So the legal analysis is much less deferential to the state government. And to those people who are like, hey, that sounds like a violation of the 10th Amendment, which keeps certain powers reserved to the states. Two answers to that. First, the Second Amendment was always a carve-out from the 10th Amendment. The 10th came after the Second. Second, as its application to the states, that was clarified by the Civil War and the post-Civil War constitutional amendments, particularly the 14th Amendment, that borrowed all of those other amendments and enforced them against the states. So there is no 10th Amendment analysis, in my view, to do here. The Second Amendment clearly applies to the states, so its clear, specific languages to this issue trumps the 10th Amendment, trumps the Ninth Amendment, though the Second Amendment is kind of an enforcement of the Ninth Amendment. And the net effect of it is that these laws now, it'll be very difficult for state governments to restrict gun laws. In my view, guns should translate to knife laws easily, because as the Supreme Court has previously said, the Second Amendment is really a self-defense right. I've argued that it should apply to state criminal proceedings, a range of other proceedings. They haven't yet done that, but the logic of it would. I mean, Scalia in Heller said the right of self-defense is what's protected under the Second Amendment. The right to keep and bear arms being merely the most effective means of doing so. It's also a right of individualized military, but that they haven't followed through on logically.